Your Honor. I appreciate it.
Have a great day. Thank you.
One
Sorry
last
you-
question, Your Honor.
Yeah.
Once
If he
you
doesn't
guys
do
set-
anything in 21 days, we're gonna have to figure out a way to collect. You could do a creditor's exam
A routine civil court session quickly turns into a lesson on how missing paperwork can decide a case before arguments even begin. Multiple disputes, unexpected rulings, and one emotional business battle await. Subscribe, like, and share for more dramatic courtroom breakdowns you won't want to miss today.
versus Robin Nickrand, 2505159.
Good morning, Your Honor. Frank Price, PA 2598 on behalf of plaintiff.
Good morning, Your Honor. Gary Epps, P 046306, subbing on behalf of Jeff Horowitz, on behalf of Robin.
Give me 1 second, gentlemen. Sadie, I already gave you one with these two guys. I'm not gonna repeat their P numbers here, okay? All right. Any resolution?
Not at this time, Your Honor.
All right, we're gonna do the same thing then.
Well, actually, I
Discovery-
think today is a motion for summary judgment, actually.
Oh, that's right. That's right.
Yep. It
Yeah.
appears my client doesn't believe in answering motions for summary disposition, so I'm going to have to indicate I can't oppose it because I don't think he filed an answer in an affidavit.
Well,
I can say, Your Honor, that we'll likely could probably just move forward with the motion for summary judgment today. Attorney Apps and I have also made settlement discussions. Despite the judgment, this is still most likely to end up in some sort of payment plan and settlement.
yeah, but they did file a response.
Yes, they
An
did.
affidavit too, sir? An affidavit too?
No. Let me double check that.
I thought it was a two-part requirement.
He's arguing basically that discovery is permitted but we're done with discovery, aren't we?
Yes, we are, Your Honor.
We're not.
Yeah, go ahead.
No, you go ahead.
This attorney tends to send appearance counsel when oftentimes he's making arguments in the answers that are not support. I don't even know if supported is the right word, but not properly. The proper actions have not happened prior to him making the arguments, such as arbitration. So I believe we could just move forward with the motion for summary judgment.
Go ahead.
Okay. Sorry, 1 second. I clicked off to go to his answer. Let me just bring it up 1 sec.
I think the term's called a responsive pleading, and none of the people I sub for ever seem to know what that means.
All right, I'll read this in real quick. This motion is being
Stop
brought under
subbing for some
NCR.
of those people, Mr. Apps. I don't know what to tell you.
I'm sorry, sir?
I said, maybe you should stop subbing for some of those people or all of them.
No,
Well-
don't stop subbing for him, Mr. Apps. What fun would we have?
They pay me for doing this, sir, and otherwise I have to find a real job. So I'm not going to kill the goose.
Go ahead, Mr.
Sure thing.
Mr. Price.
Motion. I'll do this real quick. Motion is brought under MCR 2.116 C9 and 10. Defendant has failed to state a valid defense to the claims asserted and has failed to assert facts giving rise to issue of material fact. We attach as Exhibit A copies, detailed account statements showing knowledge and use of the account. Defendant's answer potentially not filed correctly doesn't really touch on any of that particularly well. Brings up arbitration, even though they never tried to compel arbitration. So based on our filing, we basically stand on our document and ask for motion for summary judgment this time.
Any response, Mr. Apps?
I think he has a very eloquent explanation, sir, and I have no defense.
I'm going to go ahead and grant plaintiff's motion for summary disposition pursuant to provisions of MCR 2.116 C9 and C10. I'm going to ask you to give me your breakdown and we'll enter a judgment now. Okay,
Sure thing.
counsel? Go ahead.
Let me bring it up. Second. All right. So we have original damages of $2,640.46. Court cost of $157.26. That's $75 in filing, $20 for motion, $62.26 for service, for a total judgment amount of $2,797.72. this particular creditor does not seek any statutory interest rate.
All right, judgment will enter. So summary disposition granted, judgment will enter in the amount of 2797.72 in favor of plaintiff and against defendant. So you can submit your judgment. I appreciate it.
Your Honor, I
very
do
much.
have a judgment
I was
that
gonna
was submitted
say,
with the motion, so I've
It's page
sent it to your
15,
box.
but I can resubmit if necessary.
Whatever you
I've
want,
sent it
Jen.
to
Bring
his
it.
signature box. You're good, Judge. It's there for you to sign.
Excellent.
It's in the back of the packet.
No, on M-File. When you go in
Right.
to log in later, it'll be there.
Got it. You're all set, gentlemen. Have a great day. Thank
Thanks.
you.
Yeah,
And let
thank
me
you,
just check
everybody.
in. Can I just check in real quick on McDaniel? It was still on the ROA, but we did file a dismissal.
That when we have off, Your Honor. We
Okay.
did get the dismissal.
So you're
Thank
all
you.
set.
Thank you very
Thanks.
much, Your Honor. Have a good one.
Thomas Burton versus James Metzger, 2601197. Mr. Burton, state your name.
Thomas Burton, sir.
Oh, this isn't good. Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God.
Yes, sir.
Your page, my page cuts off. You gave him 1446.11 for custom what? The V there is all I see.
Oh, they're custom truck parts, sir.
And they took the money and never provided the parts.
Yes, sir.
And are you still out $1,446 and
Yes, sir.
11 cents?
That's correct, sir.
Okay, you're welcome.
I'm gonna go ahead and give you a default judgment. This is your day to be a lawyer if you want. I'm just kidding. Anything else? You have
No, sir.
$1446.11 plus you have your filing fee in the amount of $18. Do you have any other out-of-pocket expenses?
Yes, Your Honor. $51 to send him additional documents. That was
To
sent
send
last
who
week.
additional documents?
Mr. Metzger, there were follow-up documents that were submitted to the court and submitted to him as well.
And Your Honor, his filing fee was $50 and there was an $18 service fee.
Oh.
So it was $68 total.
What's he talking about with the documents, Jennifer? Was that in conjunction with the case or beforehand?
That may have been him sending him the documents that are printed in your packet, because he would have
Nice.
mailed a copy to opposing party of everything he was filing with the court.
Yes, Your Honor. That's it.
Where'd you have the documents printed at?
I printed them myself, and then I had the UPS store ship them for me.
I
Certified
see.
mail.
And that was $56?
$85, sir.
So I got 85 plus 50 is 135 plus 18 is 153. On my math, you're getting 1599. And if you think I'm wrong, please tell me. 1599.11, because I'm giving you.
The plaintiff wins by default, but collecting money is another challenge entirely. Notice how the judge carefully calculates every filing fee and expense before entering judgment. Even a single dollar matters in court. Would you have requested every recoverable cost? Share your thoughts below today.
I'm giving you the $85, the 15, and the I'm sorry, the $85, the 18, and the 50. So 1599.11. We will send out the judgment, and you're all set. I wish you well.
Thank you, Your Honor. I appreciate it.
Have a great day. Thank you.
One
Sorry
last
you-
question, Your Honor.
Yeah. If
Once
he
you
doesn't
guys
do
send-
anything in 21 days, we're gonna have to figure out a way to collect. You could do a creditor's exam and perform that by Zoom. He'd have to come here. But you're gonna have to, I would talk to a lawyer, or you can do the best research you can online. I can't really advise you. You can garnish wages, you can garnish bank accounts, you can garnish tax returns, but you're gonna need other information to do that. So
Your
probably
Honor.
gonna want a creditor's exam, require him to bring all of his pay stubs and tax returns, house deeds, bonds, stocks, car titles, etc. Okay?
Your Honor,
Understand,
if
Your
I
Honor.
may.
Yeah.
There's a website that might help him that he could do some looking at. It's Michigan Legal Help. help.org. It's all one word,
Michigan Legal
Help.org.
help.org.
Help.org. Okay.
Okay.
And on our math, we came to $1,611. I know it's $1, but that was the total amount once we added everything up, Your Honor.
Well, you got 1446.11, right?
Yes, Your Honor.
And then you got 18 and 50 in
51.
costs, which is 68, plus 85, which is 185, 135, 153, 153 plus 1446.11 should equal 1599.11.
The mail-in or one of the processing fees was $51, not 50.
All right.
End of the day, Your Honor, it's $1. I'm good.
No, I'm going to change it for you.
It was the filing fee, Your Honor, for 51.
No, I get it. So it's $1,611, right?
Yes, Your Honor.
Yep, that's what I get with that extra dollar. You're all set. Have a great day. Thank you.
Thank you, Your Honor.
Bye now.
Bye.
Capital One versus Huey. Thaddeus O. Huey Jr., P504223.
Dylan Clark, P88474, here on behalf of plaintiff.
All right. Is Thaddeus Huey here?
He's not checked in on Zoom, Your Honor.
Okay, you can go ahead and proceed, counsel.
Your Honor, I'll rely mostly on the brief and keep this short, but the credit card statements attached to plaintiff's motion specifically required monthly payments, and Mr. Huey defaulted by failing to make the required payments.
Can you speak up or something? I don't know.
Yes,
I'm not catching the rip.
Apparently, I need to invest in a new microphone. I apologize for that.
That's all right.
No, in this matter, there's no question that Mr. Huey defaulted under the terms of their credit card agreement, and as such, the default provisions of the credit card agreement became applicable. There is no genuine issue of material fact in this matter, and accordingly, plaintiffs entitled to judgment in the amount of $7,520.10, representing damages in the amount of $7,354.40, plus court costs in the amount of $165.70, with interest accruing at the statutory maximum of 13%.
You got 75, 20, 10. Is that right?
75, 20, 10, Your Honor.
All right. Plaintiff's motion for summary disposition is granted. There's no genuine issue as to any material fact. So pursuant to MCR 2.116C10, the motion's granted. Judgment will enter 75-20 and 10 cents. You're all set. Submit your judgment. Be good.
Your Honor,
Thank
I
you.
have that proposed judgment already, so it'll be in your box for signature.
Perfect. Great. Okay. Thank you.
Awesome. So just to clarify, the order submitted will be signed?
Yes.
Yes.
All right.
Yes.
Thank you so much. Have a great day, everyone.
Have a good one. Ford Motor Company versus Tilira L. Mosby.
Your Honor, that's a 10:30. The parties just checked in and I just put them into a breakout room.
Do I have Independence Capital versus Pavlich?
I do not yet.
Do I have Brooke Gorham versus Eastern Account Systems of Connecticut?
I do not yet.
Do I have Amy Lawrence versus Greg's Auto Service? 2600529. You provided your name.
Henrik Murad.
Your name. I'm going to ask you to both raise your right hand again. You solemnly swear affirm under penalties of perjury that the testimony you give in these proceedings will be the whole true self you got.
I do.
All right. I got some questions for you. You brought me this guarantee. This is over the lease. Was there not a separate business agreement where you purchased assets?
Yeah, I have the purchase agreement here.
Well, why didn't you give me that? That's what I wanted. Can you hand that to my court officer?
Now the courtroom shifts from straightforward debt cases to a far more complicated business dispute. The judge immediately starts asking detailed questions because ownership, contracts, and liability aren't always as simple as they appear. Every answer could completely change who is legally responsible for the claimed damages.
That's the purchase agreement that we did. That's the whole front.
No, this is the personal guarantee. This is the only agreement you guys entered into?
Yeah, that's when we did it at the lawyer's office on Ford Road, and that's the papers that we did. And that states the other owners' names and
That you're gonna pay the lease. Did you, who owns the assets now?
the owner of the building, their names is Ali Saad and
Do you know this owner, whoever owned the Greg's Auto Clinic when you bought it?
it says it on the paper, on the second page. Greg's Auto Clinic, that's what.
Right.
They own. Yeah, on the second page at the top, it said, Sain Hamadi and some other name, Allah.
Hussein Hamadi and Allah Talib, right?
Yes,
Do you know those guys?
I don't.
Did you know them before you purchased this?
I had no clue about it. Nothing.
How did you get in contact with them to purchase this?
My partner knew that they wanted to sell the business. And so we talked to them, then we found out the building is not theirs. So we went to the owners of the building, we talked to them, and then we did the agreement. And I took over and I changed the name to Greg's Auto Services LLC. They had it as Greg's Auto Clinic at that time.
So everything, the agreement that you entered into, you have no other agreement other than this.
That's the only thing I had.
So who did you contract with the tenants of Greg's Auto Clinic?
Yeah, Twins. They're called Twins Auto Sales. They have a lot of dealerships. So that's the people that have purchased the business. That's who I'm renting as of today from them. Twins Auto Sales. Ali and Abdullah Saad.
Yeah, but
The other people, Your Honor, they were renting also from Ali and Abdullah Saad, the twins.
and now you're renting direct from the twins.
Yes,
And this is the only agreement you have.
it's the only like did the agreement.
That's why I was confused when I said they took it to a sister shop in Redford, which Twins Auto does have a dealership in Redford, but this other dealership is
Okay,
not.
let's talk about what kind of car repairs that you had to have done.
I had a whole engine put in, and
When was that again? Because I don't want you to think I remember much.
no, I know you have a lot of cases. I put the deposit down for my engine on October 7th of 2024.
And you put it
Yes, that's the end. Because then I had to pay.
October 7th of
The
24.
whole engine was $55.89.
Wait a minute. You put a deposit for the engine on October 7th of 24?
Right, and then I didn't get it back until.
Wait a minute, slow down. And then how much was that for again? 55?
$55.89.
And that was with the predecessors to this gentleman and his company, right?
I assumed it was the same guy working with him. Like I said, I've never dealt with the same mechanic more than once, ever, throughout this whole process through any shop.
Okay, so I'm gonna need to take my time on this. I'm sorry. Let's start completely over. I apologize. I didn't write. So you gave him 5589
Was the cost of the whole engine.
on October 7th of 24.
Correct.
And had the work been performed as of then?
No. They took it out to the other shop in Bradford and
On their receipt, it says completed on,
All right, I just want to know.
Yeah.
What other shop? Was this Greg's auto clinic?
yes. And then they took.
And
it
who
out.
was the principal of Greg's auto clinic again? Can somebody tell me?
What do you mean?
who was the?
Well, that was the predecessor.
Someone named Sam. All he told me was his name was Sam.
Do you know who that was?
I think that's the guy from previous, Hussein Hamadi.
Okay,
Stand that over here.
all right, slow down. I know, but let's just not start. I'm trying to follow this whole thing here.
Here's where the timeline becomes critically important. The judge carefully separates what happened under the previous business owners from what happened afterward. Without a clear connection between those events, proving legal responsibility becomes much harder than simply showing the repairs went wrong or money was paid originally.
So you gave them money. Was the work completed or not performed when you?
No, they took it out.
Wait, you gotta let me finish. On October 7, 24, you wrote them a check for 5589, correct?
No, I gave them $3,000. I didn't pay the balance till I picked up the car,
When did you give them $3,000?
October 7th, 2024.
All right, but you still were gonna owe a balance of 2589, right?
Pick up my car, correct?
All right. And that you think, or so you think at least, that was when Hussein Hamadi and Ayla Talib were running Greg's Auto Clinic, right?
Yes, Your Honor.
Hang on. Just let me get my bearings here. All right. So you drop it off on October 7th of 24.
Correct.
You pay them $3,000 and agreed to pay 5589.
Correct.
Then what happened? The vehicle was taken where?
To Fast Lane Auto on 8 Mile Road in Redford.
On 8 Mile in Redford. And that's where the work was performed?
Correct.
And do you know if Hamadi and Talib owned that?
That I don't know. That I don't know. The same person I dealt with that took my car there is no longer there, and now there's been supposedly 3 new owners since then at that shop as well.
Do you know for a fact that you gave it to Hussein Hamadi?
The person I talked to told me his name is Sam. That's the first time I'm hearing.
And you think that's you?
Hussein Hamad, that's saying it.
All right, so the work's performed out at Fast Lane Auto on 8 Mile in Redford. And when do you pick up the car?
On the receipt, it says she picked it up on 10/7/1.
That I don't know why they put that, because I know they didn't do an engine the same day. That's,
No, you dropped it
That's
off on
shabby.
8/20. And then work completed on their receipt, it says 10/7. On first.
but they can't be, right? Because I didn't pick it up from Greg's. I picked it up from 8 Mile.
Yeah,
Okay, so wait a minute, slow down. Wait, let me ask you a question. Just wait a second. Wait. So you're telling me you have documentation that indicates they dropped it off on August the 20th of 24?
no, I'm seeing it off of her papers. Can I?
Yeah, I don't.
It says, proposed completion date 8/13/2024. Work completed 8/13/2024. On their work order, Greg's Auto Clinic.
It was
But this
completed?
is just the
It says
241.
completed.
That's just for them to show me all the codes.
Wait a minute,
I paid $241 just for them to.
wait a minute, wait a minute. You confusing.
Whole thing's confusing. I could sit down and explain it further.
Well, here's the problem. There's gotta be successor liability and I don't see where there is. I mean, I feel bad for you. I'm just trying to figure this out. But I don't think this company is responsible because they entered into an agreement to lease from the owner of the building, the same equipment and I have to have here as far as let me ask you a couple questions. Let me just ask you a couple questions.
Can I say something?
No,
Yes, sir.
do any of the owners that are there at Greg's Auto Service, were any of those working with Greg's Auto Clinic?
The owners of the building, they have over 100 shops. They own a lot of buildings. They rent them out to mechanic. Bless you. So they rent them out. So these guys that did,
Did you bring your own tools over there?
of course. So they.
So the tools you didn't purchase from anybody. I mean, you brought them there. You were purchasing the tools
I have.
from Greg's Auto Clinic or the owner.
No, I have my own tools. And I have all the receipts from Snap-on and Matco. So
All right.
this has nothing to do with them. They took everything, whatever they had, and they left. They said they're moving down to their new location. And then their sister-in-law at the time, she knows her. Her name is Brittany Coquel.
This testimony explains why the case became so confusing. Multiple repair shops, different engine invoices, changing ownership, and conflicting records leave the judge searching for reliable evidence. Sympathy alone isn't enough. The court still needs proof linking the current business to the alleged wrongdoing before awarding damages.
She was still working for me, and they didn't even tell her that they're done from.
All right. Let's talk about the issue of the engine. What's wrong with the engine?
Nothing now. My car runs like a champ now.
How much did you pay to have it? Tell me what happened when you picked it up from Fast Lane.
And actually, that's what I was just thumbing through and wanted to point out here. The paperwork, and that's what threw me off. They're trying to make it sound like they put two engines into my car. And because the first shop didn't replace the turbo, it blew this engine. So now Fast Lane gave me a receipt January 27th of 2025 for the second engine that I bought, or that they were putting in with no, there was no proof of the first engine, which I know they didn't install it all. They take it out to the shop that they said was their sister shop, which it isn't, because now I'm finding out about twins. And I've seen employees go
When you
back.
got the car back,
I do have my car back.
you know, but when did you get your car back?
The second engine they're saying they put in, I have the invoice date for January 27th of 2025. I want to say I didn't get it back until like the end of March.
All right. So when you got the car back the first time, right? You picked it up at Fast Lane.
Yes.
What was wrong? Right?
Yes.
What was wrong with the engine?
I made it from Fast Lane on the freeway to, I think it was 275 at Sibley exit, and the tow truck had to come and get me. The whole entire engine just died because they didn't put a turbo on that I paid for, and it blew the whole engine, is what they're saying. So then now they're getting a legit receipt for the engine, which I kept asking for the first time. Second time around, I have a legit engine receipt with everything. I think that.
Slow down. Do you know where these guys are now? Greg's Auto Service.
I'm Greg's Auto.
Well, I'm sorry, Greg's
Auto Clinic.
Greg's Auto Clinic.
All I know is they went to Fast Lane. That's where their other locations. And that's what
But then when I
told
call
them.
Fast Lane, and I even have a recording of this, they say that they sold that shop back to them and they're back at Greg's.
Ma'am, here's the problem. If I were you, I'd talk to a lawyer and have the lawyer assist you in trying to locate the predecessor owners. These guys, I cannot in good conscience, there's nothing here that tells me, wait, let me finish. Why does everybody interrupt me, John? I don't understand. I can't in good conscience enter a judgment against these guys. There's no evidence they purchased assets. It's not the same owners. It's not the same people working there. I mean, I feel bad for you. I really do. But I have to follow the law and I don't see it. And if I was you and you want to pursue this, I'd speak to a lawyer. And I would have the lawyer help you, at least give you some ideas as to
I did.
where you might turn.
I figured at the very least, Your Honor, I'd probably walk away with the name, which is probably just gonna be another ghost chase. Unfortunately, I feel like you said it's just gonna be a really hard lesson learned the expensive way.
It's terrible.
I gave you the names of the owners that took your money, and I already feel bad.
No, I know you
for
do,
what-
and I know you did try to call.
And I brought-
This is
The day I left, I found out my aunt died.
an honest,
So you're
2 days later, so that's why you didn't get back for me.
Not a problem.
this is an honest guy here.
I
Yeah.
even looked at her car and checked it out for her and added antifreeze, and I'm the one that told her they did not replace the engine. Because if they did replace her engine, it would have had either written marks on it
Listen,
from the.
where's the old engine at? Where's the
That's
old
what I
engine at?
told- I'm the one that told her to go up to court.
Where's the old engine at?
I never seen anything with the old.
By law, they should have your honor the engine and show it to the
Right.
customer before they dispute any parts.
Right.
And that's what I showed Miss Amy.
It was a core price on the receipts.
So then, if you know I'm honest, why would you write a Google review and put it that you take people to court and all that in Greg's Auto Shop and do not take your car there because they changed one word, either Greg's Auto Clinic to Greg's Auto Shop.
That is what they did.
Well, but
But you're writing it on my website, it's not me. Sweetheart, I know already you're in pain and whatever these scumbags did to you, it's not right, but you're affecting my good. And I told you, anything you need, I'll help you out. I did an oil change, I did the sparkless cleaning for you.
How would
And-
wait a minute. Wait,
How
please,
would-
please,
change your-
please, 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 please,
I replaced it.
please, everybody.
Yes, sir.
I made my ruling. I don't know what to tell you. You guys are gonna have to figure it out. There's no way I'm finding him responsible. I'm no cause of action. And you guys can go down the hall and get that. I would consult with the lawyer and have them try to,
Yeah, well, any paperwork that can be done.
yeah, they'll,
On it, or
Jennifer, give her the personal guarantee that's on there, please.
just the name.
Well, she's gonna give the personal guarantee and she's gonna give you a copy of the judgment, okay?
I appreciate it.
And Judge,
Have a
are you
good day.
sending the copy down? Because we did not put that in M file.
John's bringing it down now.
Thank you.
Thanks. Good luck to you, Devin.
Yeah, Your Honor.
You too.
Saw your appearance on TMC, by the way.
Oh, boy. Independence Capital Recovery versus John Pavlik.
The judge ultimately refuses to hold the current owners responsible without legal proof connecting them to the previous business. It's a tough outcome, but courts must follow evidence over emotion. Like, comment, share, and subscribe for more shocking courtroom stories and expert legal breakdowns every week.